All right, welcome everyone. Calling to order the meeting of the Sentencing Guidelines Commission. Today is April 9th, 2026, and I will ask our director, Nate Wrights, to take the roll.
Roll call, Vice Chair Middlebrook.
Present.
Middlebrook present. Sorry, I'm
Did I?
experiencing some technical difficulties.
Spelled my name wrong.
All right, so Middlebrook present, Commissioner Castro. Present. Commissioner Castro present, Commissioner Eade.
Present.
Commissioner Eade present, Commissioner Fraze.
Present.
Commissioner Fraze present, Commissioner Keefe. Commissioner Keefe. Commissioner Keefe absent, Commissioner Ladd.
Present.
Commissioner Ladd present, Commissioner Mazzaros.
Present.
Commissioner Mazzaros present, Commissioner Moore.
Present.
Commissioner Moore present, Commissioner Moran. Commissioner Moran. Commissioner Moran absent, Commissioner Mueller.
Present.
Commissioner Mueller present, Commissioner Reeves.
She said it, but we didn't hear her.
Commissioner Reeves.
Do you want to try one more time,
You're-
Commissioner Reeves?
Yeah, you're muted, Commissioner Reeves. I can unmute you if you like, but can you unmute yourself?
Looks like she froze.
I will unmute you. That's always dangerous. Actually, I can only request to unmute.
Is she still muted?
Commissioner Reeves. I see that you're unmuted, but I can't hear you. I hear something, but it's not your voice. It's interesting. We'll get back to you, Commissioner Reeves. I will say under the open meeting law, it is required to have audible responses. The video part is not required, but the audio part is for presence. So we'll get back to you. Commissioner Mazzaros.
We lost him.
Still present.
Oh, I'm sorry. I was looking at the wrong list. My apologies. Commissioner Saxena. Commissioner Saxena. And I know Commissioner Saxena was going to be absent, unfortunately, at a commitment. And then Chair Mitchell.
Present.
Commissioner Reeves, we're going to try you again. Okay. I heard something just there. It was
Maybe talk for a little while to see if it's. Nope,
She's freezing up.
oh.
another suggestion might be to turn off your video. It might be a bandwidth issue. Your video looks good, but try just the audio. It didn't help. Still
Nope.
can't hear you.
She left.
Maybe she'll log on again.
She might try.
This is what like it is to be in court.
Yeah, this is, I feel like I'm in court right now.
Is it?
Somebody who loves Zoom.
Exactly.
I
right.
sometimes figure out that I'm still Bluetooth to my car.
Oh, that would make a difference. Yep.
All right, so we are,
In any case, we have a quorum,
we have,
correct?
yes, so we have, we have 10 members present by my count, and for some reason, my spreadsheet is not accepting entries. So
Okay.
I don't know what the problem is there. I'd love help, but I believe it was 10 members present if you count Commissioner Reeves, who we all saw being present, and now she's back in the meeting. Commissioner Reeves, are you present? Still
Are
muted.
you able to hear me now?
Yes.
Okay, good. I just came back in, thought that would help.
All right, and I'm guessing you're present. All right, so Commissioner Reeves is present, so that's 10 members present, 3 members absent.
Excellent. Okay, do you want to take a minute to try the spreadsheet before we call
Yeah,
for
I
the next thing?
See if I can figure it out.
Yep.
Okay.
Let's see. Okay. I think I just didn't press the enable editing button. So, yeah, so we can proceed, Chair. Thank you.
Okay, so is it okay if we move on to
Yes.
approval of the agenda?
Absolutely. I can fill in the roll
Okay.
call later.
I would entertain a motion to approve the agenda.
So moved.
That Commissioner Eid and then seconded by Commissioner Middlebrook. Any discussion on the agenda? Hearing none, we'll go ahead and take a vote.
To the Eid motion to adopt the agenda, Middlebrook?
Yes.
Middlebrook, yes. Castro?
Yes.
Castro, yes. Eid?
Yes.
Eid, yes. Phrase? Phrase, yes. Keith? Keith, absent. Ladd?
Yes.
Ladd, yes. Mazzaros?
Yes.
Mazzaros, yes. Moore?
Yes.
Moore, yes. Moran? Moran, absent. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena? Saxena, absent. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
With that, the motion is approved unanimously. I'm wondering if staff might be able to turn down the sound on the folks coming in just slightly because it's a little overwhelming. Next, I would entertain a motion to approve the minutes. You all received draft meeting minutes from March 12th, 2026. You should have received them last week and hopefully had a chance to review them. I would entertain a motion to approve the minutes.
So moved. Reeves.
Commissioner Reeves makes a motion. Do we have a second?
Second.
Second by Commissioner Castro. Thank you. Any discussion on the minutes?
Something really small.
Yes.
Commissioner Eid, I apologize, but I don't want it to appear that I didn't read this. My first name is spelled wrong. It's Keala. That's the only correction I would note.
All right. So would the two folks who made the motion and second accept that as a friendly amendment to
Yes,
approve the
ma'am.
minutes as?
Yes.
All right. So we will make that correction and we are voting to approve the minutes as amended. Any other discussion? Hearing none, we'll go ahead and take a vote.
On the Reeves motion to approve the March 12th, 2026 meeting minutes as corrected, Middlebrook?
Yes.
Middlebrook, yes. Castro?
Yes.
Castro, yes. Eid?
Yes.
Eid, yes. Phrase?
Yes.
Phrase, yes. Keith? Keith, absent. Ladd?
Yes.
Ladd, yes. Mazzaros?
Yes.
Mazzaros, yes. Moore?
Yes.
Moore, yes. Moran? Moran, absent. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena? Saxena, absent. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
With that, the motion is approved unanimously. Thank you. All right, are you all caught up over there?
Yes, ma'am.
Okay, great. Then next item on the agenda is our legislative update, and I'll turn over to Nate to walk us through that.
Thank you, Madam Chair. So this is a short session and we're already significantly through it. Some legislative deadlines have passed, so in theory, bills that have not moved forward are dead, but death is a relative thing in the legislature. But I do want to talk about a couple of bills that have risen to the fore. And those are both in your packets. I'm going to start with the second one just because I have less to say about that. It's Senate File 4735 that did get passed through the Senate Judiciary Committee. I don't know of any progress for a companion in the House, but I confess I didn't research it. The reason I'm bringing that bill up particularly, though, is that it's kind of getting really close to the territory of the Sentencing Guidelines Commission. And not that that's a bad thing. I'm just letting you know that when there are bills that directly impact the the commission or the sentencing guidelines, I like to let you know about those. This bill doesn't explicitly direct the sentencing guidelines to create a new aggravating factor, but it does in so many words. So there's a list of aggravating factors that the legislature created back when Blakely was new and we weren't really sure what was going to be allowed or permitted with respect to aggravated departures from the sentencing guidelines. And the legislature adopted this. They basically took the guidelines aggravating factors at that time and statutory encoded them. And there's added to that is this new aggravating factor. Basically, the gist of it is if a defendant is an adult and commits the crime, and the victim is a minor, and the adult perpetrator facilitates the commission of the crime by pretending like the adult perpetrator is also a minor, then that would be considered to be an aggravating factor, if that makes sense. And I think there was a situation where there was an adult who was pretending to be a high school student recently that made the news and may have committed some crimes against high school students, and this is probably the origin of this particular aggravating factor. The adult was actually enrolled in high school, I think, that by pretending to be. And then there's interestingly, I mean, it's an interesting structure on how they do this, maybe unique, that they add a separate statute in chapter 6 and 9 that says that this is a permissible basis for an aggravated departure. So it's not telling the commission to add this to the list of aggravated departures, but basically, that's sort of the implication. So that's the second bill. Be happy to talk about that. And I should say with respect to these bills and all bills, I didn't bring it up, but there's a clause in your charter statute that says that the commission is directed from time to time to make recommendations to the legislature concerning matters involving the criminal code, criminal procedure, and other aspects of sentencing. So this would, if there is a legislative recommendation from the commission, this could become an action item if somebody's inclined to make a legislative recommendation. Certainly no requirement to do that, but that's something that the commission is invited to do from time to time by the legislature. So it's certainly not out of place. The second bill, well, actually the first bill, the 4A is House File 2354.
Commissioner Castro.
May I just ask a question about this one?
Mhm.
So, my concern is when they use the term a judge may consider as relevant. I mean, it's an aggravating factor. It has to be proved beyond a reasonable doubt to the jury or to the fact finder if that's the judge. So, I mean, I can't consider it as a relevant unless it's been proven beyond a reasonable doubt. So I think somebody needs to let the legislators know that that's a requirement for any aggravating factor.
And I think it does talk about that in 24410. Let's see. Which is the other change. So section 1 is changing 24410 to amend the list of aggravating factors. And so 5A is the list of aggravating factors, and then 6 and 7 and other parts of 24410 do talk about the process by which it can be considered. It is a little bit of belt and suspenders to have section 2 there as well, but because I would think section 1 would do the trick.
I just, well, like, as long as we're talking about it, this section bothers me because I'm actually somewhat surprised, or maybe I shouldn't be, but I'm surprised the courts have never challenged or have never requested something be done with this section, because it was put into law after Blakely when there were no procedures in the courts to deal with Blakely. The legislature acted more quickly, but then the Supreme Court amended the rules and brought the rules in step with the case law. And so now there's a conflict between the rules of procedure and the statutory provisions. And so the whole section, like, bothers me on that front. Obviously, our authority is delegated from the legislature, so if they want to tell us to do something, they can. But it, feels like the worst section that they could ever communicate to us, that they want a factor to be added. And it'd be better if they were to just pass a session law to say that they want us to consider adding this as a aggravating factor. Just because there's so many other, in my mind, there's so many other problems legally with this section. But that's a little bit beyond the scope of what we need to complain about.
I mean, I agree. As I read this bill, I'm not sure if the legislature is trying to be sort of deferential to the commission and not come out and tell the commission what to do, but sort of hint at it by dropping these things in these different statutes, and maybe the legislature, or maybe the commission then would pick it up and put it in the guidelines. But it would honestly be confusing if
I agree, it's confusion.
if the commission didn't put it in the guidelines then, because it'd be in statute but not in the guidelines.
Right.
So the other bill really, okay, so what it does is it has to do with medical assistance fraud, essentially. And medical assistance fraud right now is codified in its own statute. Statute's a little bit confusing because it says whoever does this is guilty of theft or attempted theft and may be punished, I think, as provided in the theft statute. So I think that way that's been interpreted is it's an attempt crime as opposed to a completed crime. And therefore you get half the statute. So I think that's one of the things they're trying to correct with this. Another thing they're trying to correct with this is the other place where medical assistance fraud is outlawed is in the theft statute itself. It's one of the provisions underneath 60952 subdivision 2A3, which is theft by fraudulent false representation. The first itemization is theft by check, basically by a false check. It's false. It's a rubber check, and you get something for it anyway. The second one is more general, and then the third one, it has to do with medical assistance fraud. This bill repeals both of those provisions and replaces it with a new scheme for medical assistance fraud, which is all well and good. The concern really comes with the penalty statute, and I should say my concern. Maybe it's not too much of a concern, but so the penalty provision. They have, there's different penalty tiers in the theft statute. And some of what I'm about to say, we're going to talk about later in the meeting when we talk about theft offenses. But essentially the thumbnail, the three kind of basic tiers are above and below $5,000 for felony theft. And the commission ranks those at severity level 2 below 5,000. And severity level 3, 5,000 and above. And then for some crimes, including medical assistance fraud, there's a third higher tier of above $35,000. And the commission typically ranks those at severity level 6. And this and those are the tiers that apply to medical assistance fraud right now. But if you look on page 3, beginning at line 23, so 3.23, it's subdivision 2 penalties. And I guess I can share that, so let me do that. So the under the penalties provision, a person who's convicted of the crime, the new medical assistance fraud crime that's created by this, the basic level is a 10-year penalty, which is sort of equivalent to the $5,000 threshold right now. And then you have a 20-year penalty, which is equivalent to the $35,000 threshold right now. But their threshold is $100,000. So they jump up to $100,000. So there's no threshold in between $0 and $100,000. Whereas right now we have 3 thresholds, right? We got the below 5,000, above 5,000, and then 35,000 above. So they kind of blow up all those thresholds in my view. And then they have a third threshold, which is the $1 million threshold. So if it's more, so the second threshold is $100,000 to $1 million, and then the third threshold is $1 million or more. So I've had conversations with the proponents of this bill. The proponent, basically this bill was written by the director of the Attorney General's Medicaid fraud unit. So they got a unit dedicated to Medicaid fraud. And I expressed the concern because it presents a ranking problem for the commission, right? So you've got, we've kind of been discussing this with our ranking projects. The ranking problem is you're sort of collapsing a lot of different levels of misconduct from, basically maybe signing a false document that doesn't actually have any financial or fiscal loss at all to the state. That would be within the lowest threshold, or $99,000 would also be in the lowest threshold. So there's no distinction between those. So how do you rank them? Do you either rank them like it's severity level 2 or severity level 3 or severity level 6, like you do now? So I expressed some concerns about that, and they're actually going to meet with me tomorrow, the AG's office. So nobody official in the legislature, but these are the proponents of the bill. So I think they'll have a lot of weight with it. So you could just give me guidance when I meet with them, or you could make an official recommendation. I would take either one. But in the conversations that we've had, I've kind of cooled down a little bit because this isn't doing what I thought it was trying to do, which is kind of blow up these thresholds. Really what that $100,000 threshold, I think the proponent's intent of the $100,000 threshold is, and we'll get into this in the theft issue, but the $35,000 threshold was created in 1987. And sure enough, if you get on the internet and you say, what is the spending power of $35,000 in 1987 today? Guess what? It's $100,000. So essentially what they're trying to do here is sort of update the $35,000 threshold to modern times. And also, guess what? When we looked at the over $35,000 Medicaid fraud cases, they were all in that $100,000 to $1 million range. They were all several $100,000 because, medical costs, right? So really, I think they'd be okay if the commission were to rank this at 100,000. In fact, they thought about just making a general recommendation of upgrading, the $35,000 threshold, but just because that's way too general, and their focus is really more narrow, they just decided to kind of start with this. I don't know if the commission wants to give me any guidance on this. I mean, I think one possible outcome or something that might be related to this is when we look at the theft statutes. I think that's a fair question to the commission is, do you want to update those thresholds? Do you want to recommend to the legislature that they update those thresholds for current times? And the $5,000 threshold was updated a few years ago for some offenses, and we'll talk about that too. But really 5,000 would be probably closer to 8,000 now if you were to, adjust it for inflation. Likewise, the $2,500 threshold is probably more like $4,000 now. So anyway, I guess I would open up for discussion. I don't know if the commission wants to make a recommendation that there be 1 or 2 intermediate thresholds there in that first penalty tier. The one that jumps all the way from 0, again, just signing a false name or something, all the way up to $100,000. And what we assumed in the fiscal note is that you probably rank that low tier at severity level 3. And then I don't know if we assumed that you'd rank the second tier at severity level 6, but I think based on what they told us, I think that would be our new assumption, that was kind of their intent, that it'd be ranked at severity level 6, and then maybe rank the $1 million threshold at severity level 7, which would be pretty high for a property offense, but it's $1 million. So any comments or direction to me or motions, anything like that? This would be a good time for that, or questions.
I have a question.
Commissioner Ede.
I actually used to work in the Medicaid fraud control unit.
Okay.
And I charged out a case when I was there under the racketeering statute, charging medical assistance fraud. And so I'd just be curious if you asked them how often they're still doing that, because I think racketeering at the time it was unranked, and I think it might still be unranked. And so some of the more noteworthy current Medicaid fraud offenses have been racketeering, and many of them have been prosecuted federally, but I don't know how often they're doing that versus a theft by swindle or what they're contemplating, but that might capture even a different level of culpability as well, that I wonder if that should factor into to how we consider this. And I guess that's my comment. And then the other question I had was, did you get, I wasn't sure if I heard you right, so is it Nick Wonka who you're meeting with?
Yes,
Yeah.
sir.
So was it your understanding that the Mafuku is opposed to the statute or is in favor of the statute and the new tiers? And they're going to be providing you feedback on that or their position?
Well, they're the ones who proposed these tiers.
They
So Nick
proposed tiers,
Walker
okay.
wrote this bill basically. So,
Okay.
but he's open to talk about the bill, but I mean, kind of understanding that, his idea of 100,000 wasn't to sort of blow up all the other tiers, but that was going to be the new. I mean, he's still blowing up the $5,000 tier, which I don't like. I think it'd be nice to have a severity level 2, severity level 3 option like we have for all other theft offenses. But I guess if the idea is that 100,000 is the new 35,000, I can understand that. And maybe that should be done more broadly for theft offenses, given that the $35,000 tiers, back from, we were just reminiscing about 80s music this morning when we were setting up the room. It's a long time ago, 1987.
It's not that long ago.
It's not that long ago, right? Well,
And that was good music too.
that was the consensus. Yeah, so with respect to your other point, they are amending the definition of criminal act here on the screen on 609-902. They are adding the new medical assistance fraud. So, I mean, they certainly have racketeering in mind. I can't tell you statistics from the Medicaid fraud unit, how often they prosecute this as racketeering, but they're certainly cognizant of racketeering since they wrote that offense in the criminal acts for which racketeering can be prosecuted.
Oh, I guess, but the other question, sorry, you could ask him is that what are they going to do? Because Mafuku used to charge some small cases, like very small instances of like personal care attendant, PCA fraud. And so what are they going to do? Are they, with these new tiers, that's your concern, right? Is that there aren't lower levels of culpability that like the guidelines will be forced to sweep
Right.
offenders on lower levels of theft, the medical assistance fraud into those rankings, right?
Yeah, right. I mean, it would be my inclination to, based on my new understanding that the 100,000 is the new 35,000, right? Which I didn't understand when I first saw this because I thought he was blowing up 3 tiers basically. Well, now he's just kind of collapsing 2 tiers. If 100,000 is the new 35,000, then he's just destroying the distinction between the severity level 2 less than 5,000 and the severity level 3, 5,000 to 35, or in this case, 100,000. So my inclination would be to ask him to consider sort of restoring that for, some of the either low monetary value cases or no monetary value cases. If you look at some of the criminal acts, like some of these are, wrong section. So some of these are like falsely making a record or altering a record, so it purports to have been, so it looks like forgery, basically, and which is not the most serious crime as far as the guidelines are concerned, but it could be, and then this, well, actually, that one looks a lot like aggravated forgery. 7 looks kind of like forgery, which is ranked even lower. So it's I guess I have some concerns at those tiers. But
I mean, I personally echo that. I don't have a problem with changing 35 to 100, but if there really were cases that were smaller,
there are.
then those are the ones I'm concerned about getting swept up into that. Because if we don't have a way to differentiate them in the rankings, then we're not going to be able to retain that severity level 2 version of the offense. So I don't know what the magic number is, but it feels like we need a little smaller bucket down there too. I don't know what others think.
I mean, I would say for consistency, it'd be nice if it were 5,000, just, I like consistency. But that's not to say there might not be a future recommendation to change 5 to 8 or something later on. Just to keep up with inflation. I mean, I think it makes sense to keep up with inflation, and there's no automatic mechanism to do that. So somebody's, I think, either a legislator has to come up with the idea, or an entity like us has to recommend, or like you, I should say, has to recommend that. But yeah, I mean, I guess if there's I don't know that I necessarily need a motion to talk to Nick. I probably need a motion to write a letter to the legislative committee. But I mean, if there's just kind of an informal sense of the commission that I could pass along to Nick, that'd be fine too.
What if folks think? Commissioner Castro?
I'm in agreement with the chair. That I think, that we should probably advocate for another tier. And that doesn't go from, 0 to 999,000. That's my thought.
Madam Chair, it looks like Commissioner Keefe is present and may have raised her hand.
Commissioner Keefe?
Or did I see that wrong?
I didn't.
Oh, she's an attendee. There's the problem.
Oh, there we go. Okay.
Commissioner Keefe.
Thank you.
can
I just wanted to be able to get to the room, so thank you. Appreciate it.
Welcome to the room.
Thank you. Thank
All right. Well, I guess one of the questions would be like, would we want to make a motion that we would take the position that we would like to see another tier in this bill, so that if it does get to an active stage, he has the ability to say that on our behalf? Or do you just want to give them direction?
I just think we'll give them direction. I don't think we need a motion.
Well, you would need a motion for me to be able to tell the legislature officially that the commission recommends an intermediate tier between $0 and $100,000. But
sorry, can I just ask, what's the timeline then? So you're gonna meet with him, the bill's already been under consideration, so if we were just to have you do something informally without a formal letter, action could be taken on the bill as written. Is that the concern, why we would want to take?
Yeah,
a
you'd
vote
be
now?
like, in case something happens between now and our next meeting, then he'd have the authority to, if it goes before a committee and there's a vote, that he'd be able to put a letter in on our behalf and even testify for us if that's what it comes to.
the cement is still wet,
Yeah.
but next month the cement will be much drier. So if you want me to make a legislative recommendation for an intermediate tier between $0 and $100,000, now would be the time.
Yeah, I'll make that motion.
I'll second it.
Okay, Commissioner Eid makes a motion, Commissioner Castro seconds. Any discussion on the motion?
Can I just ask one question?
Yeah, of
I'm
course.
looking at this. So there's currently medical assistance fraud under 466.
Yeah.
So this proposed under 467 is going to,
Replace.
okay.
Yeah, so the bill repeals 467
Okay.
and it repeals
Gotcha.
60952 subdivision
The
2.
whole thing, yeah, okay.
3.
I gotcha. Okay.
All right, we'll go ahead and take a vote on that motion.
All right, so the Castro motion to recommend to the legislature that the legislature establish an intermediate tier between $0 and $100,000, an intermediate penalty tier between $0 and $100,000. If it adopts House File 2354, third engrossment. Middlebrook?
Yes.
Middlebrook, yes. Castro?
Yes.
Castro, yes. Ede?
Yes.
Ede, yes. Phrase? Phrase, yes. Keefe?
Abstain.
Keefe abstains. Ladd?
Yes.
Ladd, yes. Mazzaros?
Yes.
Mazzaros, yes. Moore?
Yes.
Moore, yes. Moran? Moran, absent. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena? Saxena, absent. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed. One
Alright.
abstention.
With that, the motion's approved. Did you have a comment?
Yeah, just to make sure that the record's clear, it was the Ede motion, not the Castro.
Oh, did he say Castro?
Oh, I'm
That's
sorry. It
correct.
was Ede seconded by Castro. My
Wanna-
mistake.
That is
This
correct.
happened.
Yeah.
Thank you for saying that.
It's his fault.
Sorry, I missed that. All right, okay, I think so. That'll close out legislative updates. We'll move on to the comprehensive review ranking project. And looks like Leah and Matt are coming over to talk through the results from Offense Group 6.
I just want to say, while they're setting up, thank you all for your participation. I know I didn't necessarily respond to each individual email when it was received. I was just kind of trying to make sure everything is in the right bucket, but I do appreciate the thoughtfulness and attention that you gave to the homework project.
Nate, it says, I currently do not have content sharing.
Okay. Fix that. I'm not gonna talk.
Fingers crossed.
All right, so we're going to move into talking about the feedback you all gave us for Offense Group 6, which included other offenses resulting in death. The presentation is going to be an abridged version of the PowerPoint we sent out because it was quite long, so we'll focus on the data and highlights. And again, thank you for filling out the packets. We know it was a lot of work, so we appreciate it. This offense group was split into 2 chapters, state of mind offenses and misconduct related offenses, for a total of 24 offenses. You all sent them in to us and we compiled them, and now we'll go through the results. So for chapter 1, the defendant's state of mind offenses, there were 8 offenses as you see listed here. And we also put them on the grid so you could kind of see where they land severity level wise. In this chapter, the offenses range from severity level 5, the manslaughter, to negligent animal control, up to severity level 11, murder, to intentional. And we kind of broke down the analysis by the severity level in each of the chapters. So we're going to start with the severity 11 offenses, and there were 2 offenses in this group: murder to intentional and adulteration leading to death. And as you can see, there was unanimous support for murder to intentional to keep that ranked as is. The adulteration resulting in death had a little bit more of a mixed bag as far as what feedback was. And so if we talk about the highlights again, murder to intentional it was deemed as an appropriately ranked offense, and some of the reasons given were due to the lower departure rates and the level of harm of the offense. Adulteration resulting in death, again, most were in favor of keeping the current ranking, but there were also some interest in downranking. And the reasons given were due to the state of mind of the defendant, the lack of intent required to commit the offense, differences in behaviors leading to a charge for this offense. Those who were suggesting downranking were suggesting severity level between a 10 and 11 or a severity level 10 or an 8. There was also a suggestion to unrank this offense, I believe, because there have been no cases. And there were multiple suggestions for legislative recommendation to distinguish between the levels of harm in this offense. So specifically distinguish between the intent to cause death and the intent to cause only illness.
And I just wanted to point out one thing you have in your packets, like the full slide deck. Some of those slides are hidden, so you won't see them presented today. But you have some kind of additional background material that Leah and Matt won't be presenting for the sake of time.
Yeah. Any comments related to that, or we can move on? We have a lot to get through, so, but feel free anytime you have a comment to please interject.
Well, and one thing I'm realizing we have a couple of folks who are new since the last time we did this, but what we did last time was we kind of went through and where there seemed to be some potential agreement around something, or there seemed to be a desire for change by a lot of people, they would call it out. Or if there's like a lot of variation, then that's a place where if you want to talk about why that might be and if there's something we should consider there, then please bring it up as we go.
All right, so moving to the severity level 10 offenses in this group, there were only one, murder 3, depraved mind. Again, this one was unanimous to keep ranked as is. I'm not going to spend much time here, and some of the reasons were because it was appropriate due to the seriousness of the crime, low departure rates, and the proportionality of this offense compared to others ranked at severity level 10. All right, severity level 9, we have one offense in this group as well. Manslaughter 1, heat of passion. Majority of responses were to keep it ranked as is, but there were a couple responses to uprank and one to downrank. Again, to keep it as is due to its seriousness, the state of mind required, and the low departure rates associated with this offense. There was an upranking recommendation to severity level 10 because the offense is similar to murder 2, intentional. And there was a downranking recommendation to severity level 8, or maybe a new severity level between 8 and 9 due to the stat max.
Can I just say something about that? So that's the one.
Sorry,
I'm
can
talking.
you give her the microphone?
Is that the one you questioned, the stat max? I think that's the next slide on coercion.
Never mind.
Yeah. No, I was gonna bring that out, so
Okay.
that is the next slide. So, any questions? Okay, so severity level 8, we have 2 offenses here. Manslaughter 1, coercion, and manslaughter 2, culpable negligence. Again, you see the rankings are mostly to keep it as is, but we did have a couple suggestions to uprank and downrank. So this is the one with coercion, and thanks to Senator Ladd for pointing this out. I believe we had the incorrect stat max
Promotion.
on our document. You read through our documents very well, so we appreciate that. So we had, I believe the stat max was 5 years, 10,000, and it should be 15 years, 30,000. So for the manslaughter 1 coercion. So any comments kind of related to the stat max might not be relevant anymore because that was incorrectly put on the sheet.
So that's kind of manslaughter one coercion. I would say most people were okay with that it was properly ranked. For culpable negligent, there was a recommendation to uprank to a new severity level between 8 and 9 due to the culpability of the offense. And there were 2 recommendations to downrank. And one, so downrank, and the reason given there is that due to the public safety and deterrence achieved for offenses involving the state of mind, it didn't seem to make sense. And there was another comment that for people committing this offense who had a criminal history of a true 0, that they should be given the opportunity for probation if that was appropriate. All right. So now we're moving to severity level 5. Manslaughter 2, negligent hunting, and manslaughter 2, negligent animal control. And again, most were in agreement that we should keep this, or the commission should keep this ranked as at the level that it is. There were a couple responses to uprank and a couple legislative recommendations. So for manslaughter 2, negligent hunting, there was upranking justification in order to meet a stat max. For the negligent animal control, the recommendation for upranking was based on the defendant's knowledge that the animal was dangerous and to reach the stat max. For both of these offenses, there was a legislative recommendation to raise the mens rea to gross negligence. And there was also a suggestion made for both of these offenses to move them to the unranked offense list because there were no cases in the past 10 years. Any questions? I know that was really fast. And again, you have all the materials in your packet.
If no further questions for chapter 1, I'm going to move on to chapter 2. We can always circle back. All right, so chapter 2 offenses, there were 16 total. And similarly, we grouped them up by the severity level. So we'll be presenting offenses within the same severity level together again. So starting with murder 2 drive-by at severity level 11. Murder 2 drive-by saw a split between leaving the offense at the current ranking and downranking the offense, and reasons to keep the offense ranked as is included the seriousness of the offense and the proportionality to other offenses ranked at severity level 11, while those interested in downranking point to the fact that intent to kill is not inherent in the offense, similar to murder 2 felony murder.
What was the split there again?
Yeah, no problem. Yeah, so we have 7 interested in no re-ranking and 5 interest in downranking. So pretty split on this one.
Was that the biggest split?
I don't know.
One of the biggest. There was a handful that split.
Also with this offense, there was a legislative recommendation to differentiate between between intent. So if the intent was to kill, to cause death versus the intent was to cause great bodily harm. Any questions for this offense?
Was that, is intent the element or is it the harm resulting? Does anyone remember how this one's worded or this offense is worded?
It's just commit the crime and death results. All these
Yeah.
are commit the crime and death results.
So it's just the harm. It's describing the harm, not the actual, not the intent.
I think the recommendation was to include something like an addition to it that outlined whether or not the person intended to cause, like it would be more severe if someone intended to cause death or not.
That's really interesting.
But that would be severity level 11, second degree murder. So, and really, maybe it's just a nuance, but the way that this statute is broken down, there's a subdivision 1 and a subdivision 2, and subdivision 1 is intentional murder and drive-by murder resulting in death, basically. And then subdivision 2 is, and I don't know if the legislature intended for that to be a break in in severity, but that's sort of how the commission interprets it almost, because and severity, subdivision 2 is where you get your normal felony murder, which, you know, they could have included drive-by shooting as one of the felonies, and they didn't. And then you know, assault in violation of a protective order resulting in death, which we'll talk about it as well.
Anything else for this offense? All right, moving on to severity level 10 offenses. We had murder 2 felony and a murder 2 assault contrary to order for protection. Murder 2 felony, majority of responses said no re-rank, whereas there's a significant split here with murder 2 assault contrary to order for protection.
Wait, what was the up rank one again? Sorry, it was.
No problem.
Murder 2 assault contrary to an OFP. Got it. You can go.
Yeah, of course. So for murder 2 felony murder, no re-ranking was suggested due to the proportionality of this offense related to those at the severity level, as well as recent related legislative changes, FMARA specifically, to proceed before reassessing. So wanted to give time before re-ranking this offense for that legislative change to play out. Up-ranking suggestions were based on the stat max being the same as other severity level 11 offenses and the seriousness of the predicate felonies of this offense in conjunction with the seriousness of the harm caused. And downranking was suggested to mirror the severity level for the predicate offense, given that the defendant did not intend to cause death. For murder 2 assault contrary to order for protection, this one was a lot more split once again. For those who responded no re-ranking, did so due to the proportional equivalence of this offense to murder 2 felony murder, while those interested in up-ranking suggested doing so due to the seriousness of the crime, stat max, and because assaulting resulting in death with an OFP is ranked as more serious than assaulting resulting in death without an OFP. A low proven culpability was cited as justification for downranking, and legislative recommendations were made to create a task force to study crimes related to violations of OFPs. Any questions or comments here?
And this is another one that rarely gets the sentence.
Correct. There were 2 cases in 10 years.
Moving on to severity level 9 offenses, there were 6 offenses here. Manslaughter 1, assault or violent misdemeanor. Labor trafficking resulting in death. Murder 3, Schedule 1 or 2, drug sale. Abuse of a vulnerable adult. Manslaughter 1, child abuse. And aggravated witness tampering. And so manslaughter 1, assault or violent misdemeanor, abuse of a vulnerable adult, and manslaughter 1, child abuse, all were majority no re-ranking, and with very little interest in re-ranking. Labor trafficking was the one offense here that had interest in up-ranking, and murder 3, Schedule 1 or 2, drug sale, and aggravated witness tampering saw both interest in downranking as well as no re-ranking, and aggravated witness tampering had a lot of interest in legislative recommendation. And for more detail, the first section on murder 1, assault of violent misdemeanor, abuse of vulnerable adult resulting in death, and manslaughter 1, child abuse, kind of just says that the majority of people had no interest in re-ranking. Labor trafficking saw significant interest in up-ranking due to the proportionality, like a deemed equivalence in proportionality to murder 2 felony murder, while no re-ranking was suggested due to the lack of cases sentenced. Murder 3, Schedule 1 or 2, drug sale saw significant interest in downranking due to high departure rates and low culpability of the offense, while no re-ranking was suggested due to seriousness of the offense and stat max. And then aggravated witness tampering saw interest in both downranking for instances where death does not occur and providing legislative recommendation to distinguish between the levels of harm.
Director Wright.
So murder 3, drug sale, that was the only offense, I think, that there was the most common response was downrank. And I'm wondering, was that a majority or what's the no's count there on? Okay, so that's 6. So that's not quite a majority of, but I mean, that's a significant,
Yeah.
that's a significant finding that's a majority wanted, I guess if you put no re-rank and up-rank together though, it's tied.
I'm sort of wondering what people think about that one, just given that it's the first one where we have a change coming out as the higher number of people on the commission, everything else, like they're close, but not, we don't surpass keeping it the same. Commissioner Mazzaros.
So I look at this one from kind of lived experience and also, the work that I do. For me, I was a drug addict for a number of years, and every time I used drugs, I knew the chance that I was taking, honestly. I mean, maybe whatever. And the majority of people that get charged with this are people that use drugs that are suffering from the same disease as the person that takes it and ultimately loses their life for it. I also look at it as a father of a daughter that's suffers from the same disease and maybe I would look at it different if there was emotion attached, if I would have praised the Lord and whatever else that she's in recovery now and doing well. But for me, it's just a real practical standpoint that holding somebody at a high level of accountability for something that the person that knows that's using the drugs, the chance that they're taking, changes that one for me. So I guess that's my input. It's not really a legal standing or anything, but more of just my experience.
Mm-hmm. That's really valuable. Commissioner Castro and then Director Wrights.
I also was one of the individuals who said we should lower it down to severity level 8. And my reasoning is just that it's similar to culpable negligence, and it should be treated as such.
Director Wrights and then Commissioner Mueller.
I think my question's for Commissioner Mazzaros. I mean, what I hear, like kind of just in the Capitol and that kind of thing, is there's a lot of concern about fentanyl and maybe to a lesser degree carfentanil. I mean, greater concern, but it's rarer. And the idea that there's just sort of this horrible super recklessness of dealing drugs where you don't really know what's in it, and then that's how the death results, because not so much of the drugs themselves, although that's obviously something that can result in death, but because of these adulterants that are put in it. Does that change your perspective at all, or?
Honestly, I mean, sometimes the person that's addicted nefariously becomes addicted because there was, some other, like a fake pill that was pressed or whatever. Generally, by the time somebody's that far along, they know what drug they're addicted to, and they know all of the stuff that happens in that process, and that doesn't negate the fact that it's happening. I just don't think that nobody that's in that business is intending to kill somebody, because that's not good for business. And again, like, as sad as it is that all that's happening, the users also know every time they put a needle in their arm or take a hit of something, the chance that they're taking when they do that. So, I mean, obviously it's with an altered state of mind and an addiction that's nagging, but also there is some, knowledge. It would be different if it was like forced into them, obviously, or something like that. But it's a choice that's being made. That with addiction, the choice is lessened, but it is ultimately that.
Thank you, Commissioner Mueller.
Yeah, I'm one in favor of upranking this and a little background why, and I appreciate Commissioner Mazzaros' discussion on having a child in recovery. I do as well, from fentanyl addiction. And spent a lot of my time working undercover in narcotics. And so I think it's the application of this crime. The intention is for a drug dealer versus a drug user. I've written letters to the court on two individuals that on one given day, they're both users, they're both addicted. One person happened to buy that day and brought the drugs back. And if they both lived, the next day, the other individual may have purchased the drugs and brought it back. And so I don't agree with that, with charging individuals in that state or in that circumstance. However, you said people dying isn't good for business. We have intelligence and we have over the years of gang and cartel individuals spiking their drugs with fentanyl to achieve death, to sort of, move their product up on the scale to say that their product is this is really in the early days of fentanyl, that their product is stronger than other products. And so I feel this, like on the application, no, and what you're saying, I absolutely agree with. But I feel like this is intended for the drug dealers that absolutely know, when you're selling fentanyl, that someone could die. And the second you give it to someone, and I don't believe it's a choice by those addicted. And that's why I have a hard time with those with substance use disorder being charged with this crime. But there is a large portion of society that are making money off of the sale of these drugs that should be held to account. And they know when they sell these drugs that their clients will die.
Commissioner Ladd.
Thank you. I agree with the comments made by Commissioner Mueller. I actually indicated in my response that it should remain the same. As I look at the data for the departures and those that got a dispositional departure, both a true departure and then a departure at GTZ is I guess the term, and also the durational departures. But the thing that struck me and that was interesting to me, the average prison length for those 154 cases in that 9-year period was 93 months. If that gets downranked, that puts somebody has to be at a criminal history score of 5 to get a similar like sentence for that conduct. And that's a really high criminal history score. So I think on balance, I think what's happening with these is that on a case-by-case basis, both prosecutors and courts are looking at individual cases related to this and seeing if somebody should get an opportunity for probation or if they should get a lesser sentence, taking all that into consideration. But I agree, it's inherently risky behavior that everybody's participating in. And I get that everybody's taking that risk, but it's dangerous. And so I think it's appropriately ranked and I would not support it being moved. And I did have just a general question because we keep talking about this. When we talk about moving it down to be an in-between rank, what does that mean or what would that look like? So we would have an 8.5 or a 9.5 or, I mean, what does that mean, a between ranking?
It means that we'd create a new severity level that fits between the existing ones. Sort of like how we did or the commission did when severity level 7 was created.
For felony DWI? Okay.
Yeah.
So the numbers would actually then change. We would, I guess what I'm saying is we wouldn't have a 7.5 severity level.
Yeah.
Okay, that's mostly what I wanted to understand. Thank you.
Commissioner Mazzaros, did you have another comment you wanted to make?
I did. I appreciate Commissioner Mueller's comments, and I guess my personal experience of who I've seen with this charge serving time has not been, and it's been by hard work and all of that. It's been a while since I've served time, and so I'm glad for that. But the majority of the people that I've seen serving time for this crime are one of them guys that from one day to the next were the one picking up or delivering, and I haven't seen it specifically applied to higher level dealers. I guess maybe in the news I have a little bit, but it would be interesting to see a breakdown of who the individuals are that are actually serving these sentences out. So, because in my experience, it's been the lower level people that are just suffering right along with the person that happens to die and then they feel horrible about, in the process, so.
Thanks. I was thinking something similar. Commissioner Castro?
And forgive me if this is in the materials and I haven't seen it, but the average prison length, is that for executed sentences only?
Correct.
Okay.
Yes.
So somebody could have gotten a much bigger sentence, but got to stay and not been executed.
Mhm.
That's just actually complete probation. Okay, thanks.
Commissioner Ede?
I just wanted to ask, in light of Commissioner Ladd's comment, so if it was downranked to severity level 8 and and looking at where you would get to the average prison length, couldn't you still get to it as a guideline sentence at a criminal history score of 3, right? Because that would still be within the guidelines, right?
That'd be top of the box.
But yeah,
Yep.
right. Versus you mean closer to the presumptive term at the
Yep.
middle of the box at 5. I see. I mean, because you get to it right now at at criminal history score of 1 is where you get to the average prison length at the current ranking, right? I mean, I actually suggested not re-ranking, but I've been really interested in the comments that have been made. I appreciate hearing what everyone thinks.
I think this is one I'd like us to come back to when we have a little more time, because it feels a little different than some of the other results, and maybe there are ways to address some of many of the concerns that have been raised today, but I think we should at least peg this one for more discussion down the road.
Could we get something that would show what a cell would look like below the current one?
Yeah.
I mean, would it be what 8 is right now, or would it be something else?
Well, that would be what the direction that we could give, is to develop something in between 8 and 9. So yeah, we could see what that would look like. So I'm hearing, I don't know if it's possible to find out who is actually being sentenced for this versus, the dealer versus the user kind of question, but I'm hearing interest in that. I'm also hearing interest in what would it look like to put a severity level in between, at least. Okay. And then we'll just, so we'll put this on the docket to talk about again in the future. Oh, Commissioner Middlebrook, sorry. And then.
Thank you, Madam Chair. I wondered if we could, on the actual prison sentences, if we could get an idea on a little bit more detail on that. I mean, it still is a really high, I mean, it's a 32% mitigated duration on those cases. And the dispositional is 35%. So it's pretty high departure rates on both. But I wondered if we're looking at the average was 93, if we could get a little bit more breakdown on
that. Director Wrights.
Just a little bit of a historical note about the sort of fitting grids in between, or grid lines in between grid rows. In 1989, the durations of a lot of the higher severity level grid rows were doubled, or effectively doubled. That's a simplification, but and because of that, there were bigger gaps, if you will, between some of those durations, and that's really the reason why there was a room between severity levels 6 and 7 to create a new severity level 7, and then elevate everything else up. And that's probably why there's room between existing severity level 8 and 9 for another row as well.
And then I'm sorry, I missed you, Commissioner Mueller.
Fine. Thank you, Madam Chair. Just one last point on some history. I don't know when this charge came about. It has only really been, or when this statute came out, but it's only really been charged, in my opinion, probably in the last 15 years, and maybe you can speak to that as well. But when it first came about, it was with the rise of fentanyl. A lot of a lot of our powder drugs, people can't afford the prescription drugs anymore, and so they're buying handmade pressed tablets now that they, that have fentanyl in them. And so the majority of our drugs that we're seeing have fentanyl in them. And so previously when this first came about, it was specifically to the dealer. So they would buy the powder drug, adulterate it, cut it, add something in it, and maybe that something could kill someone, and that potential. So now I think there's so much death surrounding, even though fentanyl deaths have decreased significantly, thank goodness, over the last 18, 24 months. I think that's why we're seeing more and more individuals, this case being charged more and more with individuals just suffering from substance use disorder. But I still argue that this is valid for the individuals that are selling drugs and bringing the drugs, sort of the, he's a word kingpin, but the individuals that are really making the money off of this, off of powder drugs. Thank you.
The answer to the question is 1987 for both this offense and the manslaughter drug offense.
All right. Does everybody, anything else in that one? All right, sounds good. Thank you so much for the discussion. Let's go ahead and move on to the next thing, the next item.
Continuing on severity level 8 offenses. So we had 4 of these offenses, and you can see across the board the majority of responses suggested keeping the ranking where it was at. Manslaughter 1. Well, let me move on to the next slide, and we'll share the detailed results. Manslaughter 2, neglect or endanger a child, saw little interest in re-ranking. Manslaughter 1, schedule 3, 4, or 5 drug sales, saw interest in downranking the offense due to the mens rea of the defendant, absence of culpability, low number of sentences, and a stat max appropriate for a lower severity level. Riot 1 saw interest in both upranking and downranking, while the majority of responses were to leave the offense at its current ranking. Upranking interest pointed to the seriousness of the offense, while downranking interest pointed to a lack of seriousness and intent. And then swatting resulting in death or great bodily harm saw the most interest in not re-ranking, but also some interest in downranking. Downranking interest was to move the offense to a severity level that included presumptive stayed cells. And then there was a legislative recommendation to distinguish between the resulting level of harm. Any questions on these offenses here? Or comments? All right. Severity level 5, we had 1 offense here, and this was manslaughter 2, spring gun. The majority of responses suggested no re-ranking, although there was an upranking suggestion due to the knowledge of potential harm and to meet the statutory maximum of this offense. On to severity level 2 offenses, only 1 here as well. This one was duty to render aid, resulting in death or great bodily harm. The majority of responses here were no re-ranking, although there was some interest in upranking and making legislative recommendations. The interest in upranking was due to the seriousness of the offense, and legislative recommendations were to increase the stat max in conjunction with upranking the offense, while distinguishing between the different levels of harm. Any questions here? Comments? Great. Then our last offense is the sole unranked offense. And this is assaulting police horse resulting in death or great bodily harm. The majority of responses suggested no re-ranking, although there was a legislative recommendation to distinguish between the different levels of harm, similar to the last 3 offenses. And so that's it. That was our last offense. Any questions about any of the offenses in either chapters?
Any other questions or comments? All right. Thanks for your work on this. I know it was a lot. Really appreciate it. And thanks to everybody for actually getting your stuff in so they could do the work. All right. That takes us to how to tackle theft, which you have 15 minutes to
Yes,
Get
ma'am.
get us to something.
All right, so I want to, first of all, you can all thank the legislature. This is double dipping. This is my executive director's report. We had 74 fiscal notes so far this year, which is the second highest in the last decade, maybe the second highest ever. And it's also the highest we've seen in the last decade in an even numbered year. Normally that's supposed to be cooled off. And I think a lot of that has to do with the fact that there's a perfect split in the House of Representatives. So there's no sort of bad ideas. It's every idea is possibly going to make it. So which isn't the case if there's a partisan leadership. So because of that, we didn't really have time to assemble a offense group for you for theft-related offenses. And that's probably a really good thing because this was going to be a huge offense group and it would have required a lot of time and energy for the staff to do. And I'm not sure exactly how many of these offenses you would even want to look at, or even if you want to look at offense groups and the theft offense group in the same way that you looked at other groups. So in the interest of time here, I did write up some observations about these theft offenses, but there's generally this, I guess the first big question is, are you okay with the general pattern? So the general pattern is if the value of a theft offense is less than or equal to $5,000, then it's a severity level 2. And if it's more than $5,000, then it's a severity level 3. Except for a few select offenses, generally fraud and having to do with corporate swindle and theft by swindle and specifically enumerated offenses, which also have a $35,000 threshold. And as we discussed, that is an old threshold. It was created in 1987, and it was, that'd be worth $100,000 in today's money. The $5,000 threshold was upgraded more recently, but as I said, that'd probably be worth about $8,000 in today's money. When the $5,000 threshold was upgraded, basically to keep up with inflation, some offenses lagged behind due to lobbying or whatever it may have been. They were not changed. So there's several $2,500 offenses that we still see, and the legislature kept that pattern for the $2,500 offenses. So if it's below $2,500, also a severity level 2, just like below $5,000 for the others. And if it's above $5,000, above $2,500, if that's the threshold, then it's ranked at severity level 3. So I guess that's one question is, does the commission have any interest in sort of following along with the HE's idea of maybe it's time to look at some of these thresholds, particularly the $35,000 one. That's been a long time since that's been looked at. And is that something the legislature would want to, or the commission would want to recommend to the legislature? And or looking at the $2,500 limit, is that something that we want to look at? Then kind of getting more into the weeds of, and I should say, it's nice, it's simple, the 2, 3, below $5,000, it's good. You do lose some nuance, as I pointed out in there. And I guess if you were to, I would assume that most people would say that temporary theft is less serious than permanent theft. The 2A5 is less serious than the 2A1, but they're all ranked the same. It doesn't matter whether the victim is the government. It doesn't matter, what the circumstances are. It could be a cable TV provider. It's pretty much ranked the same. You do get some differentiation with some of these offenses regarding financial exploitation of a vulnerable adult, organized retail theft, and identity theft. And I would just, I'm going to come back to those in a minute, but because those three I think are, and theft with risk of bodily harm. So those 4, I think you could argue are kind of these aggravated thefts, but otherwise the commission pretty much treats all these thefts the same to the extent that the legislature lets it. So I guess that's one concern I'm throwing out there. And these are all hypothetical or rhetorical questions, unless they're not, and somebody wants to discuss them, but I'm just going to keep talking if nobody interrupts me. These, if we take these four kind of, let's call them aggravated offenses. So we got theft with risk of bodily harm, very rare that it gets charged 28. This 28 number, that's a decade's worth of sentences. So, 3 sentences a year. Organized retail theft was only established in 2023. So it's, we don't have much data on the books, but that's, no offenses were prosecuted in 2024, I guess we can say. Those I think follow a sort of a rational pattern of basically it's one severity level up, right? So instead of 2 and 3 above and below 5,000, it's 3 and 4 above and below 5,000. But that pattern is not followed with identity theft and financial exploitation of a vulnerable adult. So financial exploitation of a vulnerable adult, it goes much higher. Instead of going from 2 to 3, it goes 3 and 4. I'm sorry, 4 and 5. So it kind of jumps up 2 above sort of the aggravated level, but not so much for the above 35,000. That goes up 1 to severity level 7. So a little inconsistency there. And then when you get to identity theft, that's even more confusing because you've got sort of the base severity levels of 2 and 3 for the lower levels. But then when you get above 35,000, it goes all the way up to 8, which that 8 is kind of glows a little bit because that's the only offense that's ranked above the dispositional line for a property crime, basically. Now, having said that, the identity theft's a little bit different where it has an alternate way of assigning the thresholds, the maximum penalties, and that is the number of victims. So you could have $35,000 in loss, or you could have 8 victims, and either way you'd be up at that maximum level. There's also identity theft in connection with child pornography, or now called child sexual abuse materials, which I don't really understand how that was supposed to work. I listened to at that time County Attorney Klobuchar's testimony, and I still don't understand exactly what that was supposed to do, and I don't know if it's ever been prosecuted, but that's also ranked
And then
at severity level A.
Commissioner Eid has a question, so.
Well, I was just gonna suggest, I think it would be helpful, like for this, in this table, to include, because I noticed in the memo part, you included when some of the thresholds were established in the different statutes. And the reason why I think that's relevant is I think you make a really good point, especially in light of what we talked about with medical assistance fraud, about considering changing the thresholds in light of the changing, inflation and the value of money over time. But some of the offenses, like when you're talking about the vulnerable adult, and I noticed wage thefts on here too. I'm not entirely, I think it would be helpful to know when each of the laws were amended and passed, because the effect of the loss of under $5,000 to a vulnerable adult, or in a wage theft situation where the victim might be someone who that small amount of what is a smaller amount of money in today's terms might be a large amount of money in terms of their paycheck and the effect on their life, might warrant a higher severity level. I mean, I don't know. I think that kind of nuance in terms of who the statute is designed to protect, and when the legislature made those policy decisions to put it on the book. Like if the wage theft statute's a more recent, legislative change, that might make a difference, I guess, to my mind, on whether or not re-ranking would be appropriate.
Well, that is definitely the most recent form of theft that's added. That's why it's 19 on the list. But it's as far as the thresholds go, a lot of these thresholds are just kind of following the template thresholds in 60952 subdivision 3. So that's why I think the commission just does that. But again, like I said, you lose some nuance. So I mean, if the commission does consider like wage theft to be more serious than other forms of theft, or you know, it can certainly take appropriate action. I guess moving on to the second table. So I should say that another thing just to point out on severity level $35,000 is that most of these are ranked at severity level 6. I already pointed out the two upward outliers. Those are identity theft and financial exploitation of a vulnerable adult. Although one's severity level 8, which is, you know, significantly different than severity level 7 because it's above the disposition line. And then there are two lower outliers, and those are financial transaction card fraud and check forgery, which isn't on this chart. And then we get, and then quickly moving down here to table 2, we got these different thefts that are based on the property stolen or circumstances, which, you know, the motor vehicles kind of stick out as being a little different, where it's ranked at severity level 4 if it's permanent theft of a motor vehicle, ranked at severity level 3 if it's motor vehicle use without consent. But if it's any other statute, and I'm thinking here of receiving stolen property, which it commonly does involve a motor vehicle, I think we could probably give you more statistics on that because we're working on a fiscal note right now related to that. That's 2 and 3 depending on value. So it's a different way to do it rather than the ranking of 4 if it's permanent motor vehicle theft. So that's an oddity. I think that it is ranked. You know, it uses the 2 and 3 severity level if it's receiving stolen property, like at a chop shop, but severity level 4 if it's permanent, and 3 if it's motor vehicle use without consent. I also find theft from an abandoned or vacant building under $1,000 to be odd at severity level 1, since that's really almost indistinguishable from third-degree burglary, which is ranked at severity level 3. And then table 3 lists forgery, corporate crimes, and so forth. And that state lottery fraud over $35,000 is unranked. And there's check forgery at $35,000 or more. And finally, we get to burglary and theft tool related offenses. This one I just find odd that possessing or using a scanning device or reencoder is ranked at severity level 2, whereas the other theft tools are ranked at severity level 3. I'm not sure how that's really different than, say, possessing a code grabbing device or possessing shoplifting gear. Particularly odd since identity theft is treated pretty harshly, and this falls under the category of identity theft, possessing or using a scanning device or reencoder. So I guess I'd welcome any direction that you have for us on how you'd like to tackle these theft offenses in just no time. We have no time at all on the clock. So
We do not have any time on the clock, but does anyone have any initial thoughts that you want to get out?
I mean, this is something you want to tackle. And we're not going to have time today to talk about the sex offense grid or the sex offender grid or the drug offender grid. But those are also, you know, questions of what do you want to look at next, I guess.
Yes, Commissioner Ladd.
There's a lot of offenses on here that don't have any offenses. And so I don't want to say I don't care about that, but I don't know how we make rational decisions without data to like change it higher or change it lower. So I sort of feel like that might be a way for us to condense sort of not looking at those per se. I mean, I think we can, but I'm just saying it's really hard because there's not data that's associated with those offenses. That's just one thing that I did notice, and I think that it's hard to make decisions about that, even if you can draw correlations to other things, but that's just one observation.
All right, Commissioner Mazzaros.
I would have much more interest in the sex offender grid or the drug grid personally.
Okay. Commissioner Castro.
Yeah, other than having a conversation about, you know, the threshold amounts, I'm not so sure that I want to delve into these different types of thefts.
No appetite?
It's not juicy enough. Oh.
Any other comments? Commissioner Eid?
I would agree with Commissioner Castro. But I do think that, I mean, especially since, you know, the Attorney General's office is thinking about this with the medical assistance fraud statute, that it makes sense to say something. But I just would reiterate my concern about, I mean, but you know, the wage theft has no sentences either. So, I mean, but I think there's probably some specific offenses on here that lower thresholds might make sense for higher severity levels, but there are some that it doesn't make sense to have $35,000 be the most as severe as it is, you know. So.
All right. I think we don't really have enough time to make a decision today. So we'll talk about approach. I mean, the question would be if there's something that jumps out at people that we should look at, I think it would be really helpful to identify that for staff. So if anyone has anything on here that is jumping out, then I would urge you to do that so that we could maybe take a look at a couple of individual offenses. But I'm not hearing a lot of love for the big project.
Yeah, I mean, the elevator pitch on the drug and sex offender grid is this. So the drug offender grid was recently looked at in 2016, 2015. The commission spent a lot of time, and then 2016, the legislature spent a lot of time, and it's now new as of 2016. So that's more recent than the sex offender grid, which was last looked at holistically in 2006. Having said that, some of the offenses on the sex offender grid were looked at more recently, namely sex trafficking and child pornography, aka child sexual abuse material. So, but what hasn't been given any good look over is the actual criminal sexual conduct offenses themselves, which are kind of the heart of the sex offender grid. So, I mean, if that's something the commission's interested in, we could look at that.
Okay. Let's think about it. And then again, if there are specific areas that anyone's interested in us looking at, I'd like to hear your case for it too. So we are at time. So if people need to leave, please go ahead and do that. But we do need to at least jump down to the public comment section.
Madam Chair, there are two members of the public online. I'm sorry, there's one member of the public online. So if you'd like to make a public comment, please indicate by raising your hand at this time. Oh, she's gone. Okay, so nobody, so just be anybody in the room, and it looks like it's just staff. So I think we can safely say no members of the public are interested in making a comment. You do have a written public comment in your materials. This is, you may recall this name from, Mr. Molina also gave another written comment while he was still in the custody of Commissioner of Corrections, I think last fall, that you had a look at. And this is kind of the same idea, basically the advocacy for looking at prior offenses under one of the statutory definitions of prior offenses, that the offense had to have been convicted prior to the current offense for it to be really counted as a prior, which I point out would solve the Hernandezing issue. So that might be something to refer to the Hernandezing committee, Madam Chair.
We did talk about it today in the Hernandezing committee. So I just encourage all the members to take another look at that. But we did talk a little bit about it.
And do you want to give a report, or is that the report for the?
Oh, for the Hernandezing committee, just for folks. Yeah, we did meet today. We were really talking a lot about what is a prior, what is a crime spree, how are the ways that cases are charged, and how does Hernandezing intersect with charging practices and sentencing practices. And then we mostly kept it at the philosophical level today, and also just getting a better understanding of how Hernandez is actually used within the system. We're hoping at our next meeting to have some data to better describe the cases where Hernandezing is used so that we can start to test some assumptions that we were talking about today. So more to come. That's about it.
Regarding the restructuring committee, I just have nothing but apologies to make to the restructuring committee. I have sort of essentially been an employee of the Legislative Budget Office until last Monday. Tuesday was kind of my first day back on the job, metaphorically speaking, and just wasn't enough time to get the materials together. I will do my very best to get them together before the next meeting, so we'll have something to do.
And we will most likely do this meeting time split in May, just to give you guys a heads up of what's coming. Most likely we do this again in May. And then, but June, assuming the legislature passes anything, we don't usually have a lot of capacity in that meeting to do other things other than deal with what they send us. So that will probably be a normally back at our 1:30 time, but we'll let you know that for sure.
And we will want to be putting some, I haven't talked to you about this, but we will have some technical changes to the guidelines that we'll be asking to look at either in May or June.
Perfect. Okay. All right. Well, with that, thank you all for coming today. And unless there's an objection, meeting is adjourned. See you next month.